Good evening. My name is Stephanie Harrison, KC. I'm one of the joint chairs of Garden Court Chambers and a member of the Immigration and Public Law team. And I'm welcoming you to this seminar on what I'm going to call the illegal migration bill, because as we know, this is a piece of legislation that even the government itself can't certify as being compatible with the convention and lawful in other respects. You may have seen that this is part of a series of seminars that we're hosting over the next 3 days that will look at different aspects of the bill. People are still coming into the webinar, so I'll just deal with the kind of logistics at the moment, which I'm sure you're all very familiar with. This is being recorded and we may disseminate it more widely. So I hope everybody who is happy with that. We are going to have a Q&A, obviously, so if you want to ask questions, if you can put them in the Q&A as we go along, that would be great. The questions will be at the end. If you have any technical problems, then put those in the chat and we'll try and address those if we can. We're going to cover three broad aspects of the bill today, and we've got three expert speakers who are going to deal with different issues. We're going to hear first from Irena Sabic, who's going to talk about safe and legal routes and the control on entry. Then we'll hear from Nadia, who is looking at the implications for domestic human rights framework and the rule of law. And lastly, from Adrian on entry, settlement and citizenship. They're all experts in the field of immigration, asylum, human rights and public law, what I think might be just helpful to bear in mind from the outset is that, as someone has described it, this legislation obviously has to be looked at in its totality, because it has a single aim, which is effectively to ensure that people who travel to the United Kingdom illegally are denied any effective remedy and are shut out from all major protections, whether that is under the Human Rights Convention, the Refugee Convention, our common law, and other protections, for example, relating to human trafficking. It covers a vast area of every aspect of immigration system, as well as providing new mechanisms for inadmissibility and accelerated procedures. It excludes from protection many vulnerable groups and exposes all people, irrespective of any vulnerability or otherwise entitlement to protection, from being subject to detention, with no time limits, and critically excluding provisions that allow for challenge by way of judicial review or bail. Previous protected groups, those who are children, pregnant women, victims of human trafficking, all of those lose those protections from detention and access to procedures. The provisions relating to children also allow for the government not only to sanction its current use of hotels for holding very young children, but it also will exclude looked after status from local authorities transferring to the Home Office, and it will also, in its final clause, create, in principle at least, so-called safe routes of travel to the United Kingdom. So that's an overview, and obviously those provisions interrelate. In order to try to make it as accessible as possible, however, we're going to deal with aspects of the legislation under the headings that I've said. And obviously, if you do have questions, you're not going to be limited specifically to the topics that we're directly covering, because they are interrelated. So that will be fine if you've got wider questions. But if we can then first ask, if I could ask Irena to deal with the topics that she's covering.
Thank you very much, Stephanie. Welcome all. I'm Irena Sabic, a barrister at Garden Court. I'm a member of the Immigration and the Public Law team, and I am going to try and share my screen with you to share some slides that can be circulated after the talk. I hope I'll be able to do that. If you just bear with me for a moment. Can everyone see that? I'm not hearing any noises of dissent, so I'll carry on. So I will be speaking to you about two issues and two areas of concerns that are raised in this very concerning bill. The first being the safe and legal routes, and the second is looking at the control on arrival. So what might individuals who are coming illegally to the UK, what might they expect to face? And the safe and legal routes, I've set out quite a detailed slide there because we are limited for time. But to set this in context, I think it's worth saying that the aim of this bill, which is somewhat unusually set out in the very first clause, is to prevent and deter unlawful migration, and in particular migration by unsafe and illegal routes, by requiring the removal from the UK of certain persons who enter or arrive in the United Kingdom in breach of immigration control. And that is a really important context because it seems to me that the only way it can be achieved is by creating safe and legal routes. And it seems to me that in terms of the law, in terms of the moral compass and the political integrity, it is only if there are viable, safe and legal routes that the government can point to that this bill has any semblance of authenticity. And so with that context, I wanted to say a few things about what is firstly currently available by way of safe and legal routes, and secondly, to look more closely at what is set out in the bill. And perhaps if I start at the end, which is the clause 51, there is a cap on the safe and legal routes that's announced in the bill, and that will be determined by Parliament. And we don't know what that will be. Currently, looking at what is available, there are schemes such as those applying to Ukrainian citizens or those from Hong Kong, but they are separate from the asylum process. They are the bespoke visa system that doesn't allow access to the full gamut of protections under international and human rights law. Then there are the UNHCR resettlement schemes, which are extremely limited, they're slow and they're incremental. And what this bill does by allowing access to entry to the UK with any prospect of being treated as a human being is it's empowering itself to essentially pick and choose who comes to the UK, how and when. I've given you some statistics there in the last in the third bullet point from the bottom, that in 2022, there were 14 times more persons who were granted asylum after travelling to the UK themselves than were resettled by the British government. And that, of course, presents a clear choice for migrants who are seeking safety in the UK. And it's only if we improve the viability of any safe and legal routes that this bill has any prospect of success. The last point to make by way of general introductions is that the bill, as we'll come and see, is premised on the extension of the inadmissibility procedures. So those are procedures that don't permit an individual to make an application at all. And those have been proved to decrease rather than increase the total number of removals. So that's worth bearing in mind when looking at the purpose of the bill and examining its authenticity. Looking then in some more detail at the safe and legal routes that are set out in the bill itself, as I said at the beginning, clause 51 simply says that safe and legal routes will be defined in regulations, and they will therefore be subject only to the affirmative procedure. And the defining of the routes will depend on a number of factors, including local authority capacity and the resettlement routes offered at the time of the regulations. They're unlikely to include those on work, family or study routes. And that's all we know so far. So there is nothing in the bill that gives, in my opinion, any hope of a viable route to safety that provides an alternative for people to come and claim asylum and protection in the UK. And that's important to bear in mind right at the outset. So looking then, and I'm sorry, this is a sort of whistle-stop tour of a very small part of the bill, but I hope it's informative nonetheless. Looking then at the second area that I'm covering, which is what will happen to an individual when they arrive to the UK, and if they travel to the UK illegally since 7th of March 2023. What happens to them is that any claim that they make for international protection is declared inadmissible. And there is a duty imposed on the Secretary of State to remove them. The inadmissibility itself is permanent, so that the claim will never be considered in the UK. And there's no right of appeal, which is extraordinary. Further to that, the duty to remove is also duty bound to be executed as soon as reasonably practicable. And the removal can be to any of the clause 50 countries, which are EEA countries, Switzerland, and of course, Albania, unless exceptional circumstances apply, or to a designated safe third country. The detention powers, as Stephanie mentioned, are extended widely, and the role of the courts is restricted. And here we see the first way in which this bill sets itself on a collision course with the courts, and ILPA and others have called it to be provoking a constitutional crisis. Why? It is because during the first 28 days of detention, there is an almost complete prohibition on the review of legality of detention by any court of law. And it will be interesting, is one way of putting it, to see what happens in a scenario where there is an order for release, for example, of a particularly vulnerable pregnant woman, when the court has been specifically disempowered from reviewing detention. And that, I agree with ILPA, is likely to lead to a constitutional crisis. Further to that, if you're a child, there is a power conferred on the Secretary of State to accommodate, and almost all protection for the hard-fought and hard-won protections for victims of modern slavery and trafficking are removed by the bill. So what then is left for an individual to claim? Well, those subject to removal and those who come within the duty to remove will have an exceptionally limited period of time in which to bring a claim which is based on a real risk of serious and irreversible harm arising from their removal to a specified third country, or they could make a claim that essentially there's been a mistake of fact and they do not in fact fall within the cohort subject to the duty to remove. The bill tells us, or neither of these will be a human rights claim, and they will not attract a right of appeal, but there is the possibility of seeking a judicial review of the claim. A claim for serious and irreversible harm, and that's much more likely to be subject to litigation, so I focus on that, can be certified as clearly unfounded. And the upper tribunal appeal is available only where this type of claim is refused and not certified as clearly unfounded. So the workload of the upper tribunal is likely to be vastly increased because an individual will have an opportunity to make a claim that they will face a risk of serious and irreversible harm. And there is no jurisdiction given to the first-tier tribunal, which is, of course, much better equipped to assess factual claims. Further to that, the Tribunal Procedural Committee is required by the bill to introduce further procedure rules applicable to the upper tribunal, which set a very, very short time limits for the appeal process, with the extension possible only where it is the only way to secure justice. Again, this is the introduction of a completely new legal test that is different to the overriding objective. It's akin to the Wensbury test of judicial review. There's only one way of securing justice, and only then will an extension of time be allowed. And one can see that this is going to cause difficulties, and it has the hallmarks of essentially another detained fast-track process with built-in structural unfairness. But there it is. That is the possibility of claim that's offered in the bill. Turning next to what kind of support will be available for those whose asylum or protection claim is inadmissible. The bill makes it clear that those who are under a duty to be removed but who are not detained, and it's hard to see who those individuals will be, but the bill makes it clear that they will need access to support if they would otherwise be destitute, and the support is provided on the same basis as those whose claims are currently declared inadmissible under Section 82A or 82B of the 2002 Act. Essentially, the inadmissible claim for protection or asylum is to be treated as determined for the purpose of the 2002 Act, so that Schedule 3, which applies to, amongst others, failed asylum seekers and vastly restricts the type and level of support and accommodation that's offered, is extended to this new cohort. The last slide is deliberately short. It is looking at those who are not caught by the Act. Those are the surplus refugees and port arrivals who arrive legally to the UK and claim asylum immediately. So they are a very limited cohort. So I hope that's been helpful. As I say, the slides will be available after I've finished, but I think that's all I've got time for, and I'll hand over to Nadia if I can stop sharing my screen. Have a look.
Thank you. Thank you, Irena. That was fascinating. I think, Anusha, you're going to help me with sharing slides. Here we go. So First of all, it really goes without saying, but I think it still must be said that this really is an incomprehensibly cruel and horrible piece of legislation. And no amount of clever legal analysis is going to change that. And so to start off, I just kind of want to express massive solidarity with those who are inevitably going to suffer as a result of this bill, however unworkable it might be. And at the moment, with those who are, I know, fighting tooth and nail to try and stop it or mitigate its worst impacts as it goes through the parliamentary process. The focus of the debate on the bill is rightly on the impacts that it will have for asylum seekers and migrants arriving by small boat and other irregular means. And you have heard about the bill's stated purpose already from Irena. However, this bill is also really a tank on the law and attack on the UK's domestic human rights framework and the rule of law. And I'm going to give a very, again, brief overview of these aspects of the bill, which I agree does set us on the path to constitutional crisis. Briefly, before I do so, some background context. So this bill really constitutes the latest in a string of legislative attempts by this government to both shield itself from any accountability by the courts and to limit access to human rights protections. This bill plainly breaches the ECHR, and in my view anyway, what the provisions of the bill do is to put our domestic courts effectively in a legal straitjacket, where they are going to be left with invidious choice between accepting being stripped of their supervisory authority and independence, in effect tasked with rubber stamping the government's human rights violations, or in the alternative to engage in really a full frontal constitutional face-off of the kind hinted to in cases like Jackson and Attorney General. The composition of our appellate courts at present does make me fear that the former is more likely, and this will really play straight into this government's hands by lining up a fight with Strasbourg, which will feed into the growing noises that we've been hearing, that the time has come for the UK to leave the ECHR. Turning then to the specific clauses within the bill. So very briefly on that first slide is a summary of the provisions which have wider implications for the UK's human rights framework and the rule of law. And as Steph said in the introduction, it's quite difficult with this bill to split things out as many of the provisions interrelate. But this should provide a summary of the clauses which have implications in a wider constitutional sense beyond the provisions which, as Irena has already set out, plainly breach domestic and international human rights law. Next slide, please. So first of all, and quite unusually, the bill is accompanied by a statement under section 19(1)(b) of the HRA to the effect that the Secretary of State cannot make a statement of compatibility of the bill with the Human Rights Act, but that the government nevertheless wishes to proceed. Next slide, please. Statements of incompatibility are rare, and what they are supposed to do is to prompt anxious and heightened scrutiny of the bill by Parliament. The reported position of the government is that there is a more than 50% chance that the provisions of this bill are not compatible with the UK's ECHR obligations. Next slide, please. The timetable for this bill is outrageously truncated, and with this government majority, really the hopes for any meaningful scrutiny are a pipe dream. But it's also important to think about what this statement might signify to the courts when looking forward to any prospective and really inevitable legal challenges. And when the courts are approaching statutory provisions, which on the face of it violate fundamental rights, what they are looking for is language that is clear and unambiguous, and a clear expression of parliamentary intent. And in my view, the statement under section 19(1)(b) is likely to signal to the court that yes, this bill does run roughshod over human rights protections, but the Parliament knew that this was the case and still went forward with it. However, I would also note that from the perspective of Strasbourg, there is within this bill no attempt by the government to derogate under Article 15 ECHR, nor would this bill satisfy the strict criteria under Article 15. And so it's therefore highly likely that any claims that do reach Strasbourg would find violations of the non-derogable rights, among others. Next slide, please. Next up is clause 1.5, which is in the introductory section to the bill, which is quite interesting in and of itself. But this provision is really quite extraordinary and quite unprecedented. And what it does is seeks to disapply Section 3 of the Human Rights Act in relation to provisions made by or by virtue of the bill. Next slide, please. Most of you will be familiar, but Section 3 of the Human Rights Act is the interpretive obligation which requires courts and public authorities to interpret legislation compatibly with human rights insofar as it is possible to do so. And I've included two hyperlinks there to some of the recent debate around the Bill of Rights bill, but in effect, what has come through those reports is really the very beneficial nature of the tool under Section 3 of the Human Rights Act. But at the same time, what Section 3 has become is something of a bugbear to this government, and is one of the key targets of the Bill of Rights bill. And so in a way, it's not surprising to see that this is the provision within the Human Rights Act that is being targeted. But at the same time, this is the first occasion that a piece of legislation has ever sought to disapply part of the Human Rights Act. And considering the context and purpose of this bill, which is obviously only going to apply to a very particular group of people, what it will do in effect is to create a two-tier human rights system within the UK in a manner which is plainly discriminatory. What is interesting about the bill, however, is that it does not seek to disapply other key provisions under the Human Rights Act, for example, sections 4 and 6. And particularly given, and I will address these briefly at the end of my presentation, but particularly given the wide-ranging powers under the bill for the Secretary of State to make regulations, this is something to keep an eye on, as secondary legislation is not immune from being struck down by the courts for incompatibility with the Human Rights Act. But overall, this is nevertheless an extraordinary limitation on the court's powers, which will inevitably prevent people from enforcing their rights through the courts and will really bind the hands of our judiciary. Next slide, please. Turning then very briefly to ouster clauses, as again Steph mentioned at the start, this is a series of webinars, and I know that in part 2 of this series, the ouster relating to detention will be dealt with in some detail, and so I will just address it quite briefly. The bill contains not one but 2 ouster clauses within clauses 13.4 and 48 of the bill as it currently stands. Very briefly again, for those who don't know, an ouster clause is effectively a statutory provision which seeks to exclude the courts from reviewing the actions and decisions of the executive branch of government. Next slide, please. I have made a slight mistake with my slides. So if you could go to the next one and then we'll go back. Thank you so much. So in line with there has been a line of cases including Annis Minnick and Privacy International, which has addressed ouster clauses. And they have to date really been given quite short shrift by the court. And so the challenge for the government in drafting such clauses is no small one. What has been required by the courts is drafting that's extremely clear, extremely unambiguous. And what has been alluded to in previous cases is that the courts may never accept a complete ouster of its supervisory jurisdiction. But what the ousters within this bill do attempt to do is to severely limit the supervisory jurisdiction of the High Court. If you could go back, please. Thank you. So the first one, clause 13.4, places massive restrictions on the powers of the courts to review decisions to detain for the first 28 days in relation to the power under clause 12 of the bill. And clause 48 in very similar terms to the provision curtailing CART JRs under the Judicial Review and Courts Act 2022, places limits on the High Court's ability to review decisions by the upper tribunal in relation to appeals of suspensive claims. What is interesting to note in both of these clauses and how the courts are likely to approach them, first is the express references within both to the supervisory jurisdiction of the High Court and to purported decisions. And what's clear there is that whoever the draftsmen are have read the Privacy International judgment in some depth. Secondly, the ouster clauses are not complete and there are limited exemptions. So in the case of detention, those exemptions are limited to cases of bad faith, breaches of natural justice and writs of habeas corpus. And while it is fair to say that these exceptions will not serve as effective safeguards against the highly subjective detention powers under clause 12, nor as an effective backstop to the very limited powers of review under clause 48, it is nevertheless an open question as to whether these exceptions would in effect be enough to convince the courts to give the clauses effect. If you could skip 2 slides, please. Thank you. Very briefly then, and without going into too much detail, I would just also flag the various regulation making powers which are dotted throughout the bill. Such powers are, of course, not subject to the same levels of parliamentary scrutiny as primary legislation and are the subject of long-standing critique. But in the context of this bill, it will mean that questions with really huge implications for the rights of some of the most vulnerable people imaginable will be left to ministerial whim. So taken together, it's really clear that this bill has massive implications, not only for those immediately affected by it, but also for the integrity of the UK's human rights and constitutional framework. That's all I had to say for now, but I will pass you on to Adrian and look out for any questions that you all might have. Thank you.
Thank you. I have some slides which I hope Anisha is going to put up on the screen. I'm Adrian Berry. I'm a barrister at Garden Court working in immigration, asylum and nationality law and patron of ILPA. So my job is to talk to you about entry, settlement and citizenship provisions in the bill. And they're not particularly helpful, to put it mildly. They form part of the overall suite of provisions designed to exclude people defined in clause 2, effectively as illegal migrants on satisfaction of 4 criteria, from a range of regularization measures, including family members joining you in the UK, including the grant of in-country limited leave to remain, the grant of settlement, and also access to various forms of British nationality, including British citizenship. And extraordinarily enough, as we shall see, this new segregated form of being out with the mainstream of immigration law by virtue of being an illegal migrant is hereditary, because it will apply to your children born in the UK. So it's creating a segregated class of people in a parallel system of law who are, if you like, outlaws in the sense of being out with the law that applies to everyone else. And so that separateness is a key aspect of the bill. It's a, if you like, a vertical division between the insiders and the outsiders, even though they will be present on the territory of the UK. There will not be, in effect, a common law applicable to all people. There'll be a separate set of statutory provisions governing your civil status, your personal status. And that's incredibly important to understand. That's a feature of the design of the bill. If we could turn to the first slide, I hope. The idea is that you'll be locked out of the ordinary immigration law procedures. And so you won't be able to secure re-entry, residence, citizenship, and any saving or citizenship, and any saving provisions which are put in largely to show that there's some sort of residual discretion or flexibility or exercise of judgment, come nowhere near rescuing you from the fundamental breaches of your fundamental rights. So the idea is, as Irena set out at the beginning, you'll be locked out of having your claim processed in the UK. So the default position is you either leave and then try to, if you want to come back to the UK, then you might be able to use immigration law in the ordinary sense, as we've understood it hitherto. Or if you remain, you'll be unable to regularize yourself, you'll be unable to work, of course, and you will either, the choices will be detention or being on a form of Section 4 asylum support. And so there will be no prospect of your integration and regularization while you remain on the territory of the UK. So if I could have the next slide, please. And so the default position in effect will be that you'll be shut out before you're re-included in any fashion, because the inadmissibility of your claim won't be in the exercise of discretion, but by operation of law. Such inadmissibility as we've had hitherto has led to litigation such as the Rwanda litigation, but also inadmissible asylum claims generally, which have been a feature of our law in the exercise of discretion for a number of years. That executive discretion to declare a claim inadmissible is going to go, and therefore it will be baked into the legislation that your claim is inadmissible. There'll be no flexibility, and that will avoid pesky immigration lawyers bringing claims like the Rwanda litigation to challenges on the exercise of discretion or judgment to bring claims inadmissible. So it's not simply, although it is serious enough, that Section 3 of the Human Rights Act is excluded as an interpretive tool from the when you come to construe the provisions of the Act, and is replaced by Clause 1, which has its own sort of self-referring purposive clause for interpretation. It's also that there is this whole removal, if you like, of executive discretion, the prescription of otherness, of illegality. And the point about that is it makes various claims which have been justiciable hitherto, makes them non-justiciable. And that's one of the things which makes it more difficult to challenge. And then you'll be scrambling to catch up, to try and secure advice and representation, to make submissions, to secure funding. Another feature of this bill is it says nothing about legal aid. It doesn't even have the provisions that we saw in the Nationality and Borders Act in respect of priority removal notices, where you were sort of bunged 7 hours of legal aid support in order to try and negotiate your way through what would be described as a Byzantine system of immigration appeals, if it wasn't an insult to Byzantines. And so you end up with a provision where much of this is essentially, in terms of accessing advice and therefore legal remedies, is inaccessible to you, because there are no obvious legal remedies that are funded under this bill, and it remains to be seen how that is going to work in practice. If we have the next slide, please. And so what you have is the creation of a pool of people in the UK who are irremovable, because back in the real world, away from the clauses of this bill, there aren't admission agreements to third countries at scale. They don't exist, and all the little day trips to Rwanda for the purposes of media consumption, or giving of hundreds of millions of pounds to the French in the hope they might build a camp in northern France, is not going to deal with the fact that if you have 40, 50,000 people per year claiming asylum in this jurisdiction at the moment, there aren't removals provisions in force for 40 or 50,000 people every year to be removed to third countries or to their home countries or to northern France or to Rwanda or wherever. So the pool of people in the UK shut out from regularising their status via asylum claims will just grow year on year, month on month. And the only options, given that you are prohibited from work, are to be on Section 4 style asylum support or in detention. And so this population will grow. There's no capacity in B&B and hotel accommodation for Section 4. There isn't an immigration detention estate in the United Kingdom, thankfully, large enough to accommodate all of these people. And none of this, of course, is costed at the scale necessary. So there are very, very difficult questions about not just about the unethical nature of the bill or its incompatibility with binding instruments of international law, but in terms of efficacy as well. It simply doesn't correlate to the real external world of immigration control in the United Kingdom. And so you'll see that this denizen subclass which will emerge will just be growing in size. Will have a shadow population, not just of people who are irregular here, but people who are controlled as never being able to regularize themselves. That's what's contemplated under the bill. And we need to be very clear about that is how the bill, if it's effective at all, that's what it will do to create. It will grow the problem of unregularized people by orders of magnitude to the point where there is no possibility of their settlement and integration and acceptance into UK society, because they will be literally outlaws. If we can have the next slide, please. And so who does it apply to? It applies to all those requiring permission to enter or remain, including asylum seekers, not just limited to asylum seekers, who arrive without prior entry clearance or a relevant electronic travel authorization, or who enter without permission, or have used deception, or who've been deported. So that's the 5 categories of people to whom it applies. Of course, it applies from the date that the bill was first announced, not from the date it's enacted. So that's what the significance of the 7th of March of the date. And if you are that person or the family member of that person, this bill is for you in terms of how it's going to operate. If we can turn to the next slide, please. And so, and then to whom the measures apply is where you have not, and this is a key phrase, come directly to the UK from a country in which your life or liberty is threatened for reasons of, well, obviously as a refugee convention reason, looking at the first bullet on the page, and then it specifies by statutory provision, you won't have come directly if you stopped in or passed through a country where your life or liberty were not threatened, so France, for example. And so the focus of the clause or the bill is on asylum seekers who seek refugee convention protection. But remember the 5 classes of people we just looked at to whom it can apply on the previous slide. But it's not limited to asylum seekers. It extends to anybody who fits within those 5 classes of people: arrivals without entry clearance, irregular entrants who are not seeking protection, and so on and so forth. But if you read this particular provision, you might think, oh, this is all about asylum seekers. It's actually broader even than that when you look at the bill. And then if we turn to the next slide, please. And so the Home Secretary, of course, will be under a duty to remove them. That's baked into the provisions of the bill. It will apply to the principal person arriving, but also to their family members, including spouses, partners, children, adult dependent relatives, and so on. And those people, while they are here, will be under a duty to be, the Home Secretary will be under a duty to remove them for so long as they're here and haven't left. They cannot be given permission to enter or remain in the UK, subject to tiny exceptions in respect of unaccompanied children or victims of modern slavery. And then their family members can't be given permission to travel to the UK by securing an entry clearance or electronic travel authorization. And of course, that blatantly is incompatible with Article 8 of the Convention on Human Rights, and the best interest of children as it's protected both by Article 8 and Section 55 of the 2009 Act. And hence the inability to certify this claim, among other things, the inability to certify this bill as compatible with Human Rights Convention protection. And then if we look on the next slide, please, we'll see that if you go out and then you wish to come back in, the subsequent conferral of permission to travel or time-limited permission to enter or remain, there are narrow exceptions if the Home Secretary considers it's necessary because the UK is bound by international law, such as the Human Rights Convention, but not limited to it. So there might be something like in the Status Protection Convention on the Protection of Stateless Persons, or the Withdrawal Agreement, or where she considers there are compelling circumstances that render it appropriate. So the power goes to her, and the question of human rights compliance is of course pegged back because there's no interpretive tool via Section 3 of the Human Rights Act. If your subsequent conferral of indefinite leave, so not limited leave, the discretion is limited solely to those cases where it would breach international law not to do so. There's no additional discretion where there are compelling circumstances that render it appropriate to grant indefinite leave. So even if you do manage to get time-limited leave, you might never get to have the durable solution of being settled in the UK on a subsequent referral. So if you think about how this is supposed to work, subsequent conferral of permission sounds a bit obscure, but imagine you are removed to Rwanda and then you apply to come back. That application to come back would be a subsequent conferral of permission if it were granted. If you came back in, you might be on endless chunks of time-limited leave to the last syllable of recorded time, if there was no international agreement that compelled the Secretary of State to grant indefinite leave, because because she would then have no discretion as a matter of statutory provision to decide that there were compelling circumstances that made it appropriate to grant permission. Have the next slide, please. And then immigration rules will be required to provide, so this is Parliament telling the Secretary of State what to do in terms of the rules that she then lays before Parliament under Section 3 of the 71 Act. Well, if no exception applies, any application, so entry clearance, leave to remain, and so on, will simply be void and will not be considered. And of course, this baking in of the removal of executive discretion means that there is the options for applications and thereafter for legal challenges will be much reduced. There's no attempt to show that this is necessary. Of course, we're all very familiar with the general grounds of refusal, which confer a wide range of powers on the Secretary of State to refuse categories of leave to enter or remain. And none of that is considered. It's simply now Parliament sort of stamping on the idea that you might be able to make an application at all, rather than saying, yes, you've made your application, but it's going to be refused in the exercise of judgment on general grounds. And then if we can have the next slide, please. And then we see that this extends further into British nationality. Now, nationality law, although the threshold for deprivation now mirrors the deportation test on grounds of conduct, nationality law has traditionally been a little bit separate in terms of its approach. It represents, if you like, the conferral of it, the gold standard of belonging, the law, that you are attributed to the UK. But the idea is that your original journey to the UK, if it fulfills one of those categories we looked at the outset, to make you an irregular migrant, what's currently found in clause 2 of the bill, will shut you out on a lifelong basis, not only, and this is about journeys to the UK, from British citizenship, but were it to be relevant, from British overseas territory citizenship, which of course is the law pertaining on nationality to the remaining overseas territories where those people are not additionally also British citizens. British overseas citizenship, there aren't too many new British overseas citizens these days for the residual category of sort of post-imperial nationality designed not to allow you to come to the UK, and then British subject status, which is sort of similar in many respects to overseas citizenship. But we only need to focus on British citizenship because that's the principal category. But just to say, they've left no stone unturned in trying to exclude you from various forms of British nationality. And these proposed measures will apply to you if you arrive on and after the 7th of March 2023 and fall within the clause 2 exclusionary one of the clause 2 exclusionary categories, and your children also who are born in the UK on or after the 7th of March. So that's the hereditary exclusion of you from citizenship and the segregation of you from regularization. You won't be able to have British citizen children and therefore to be able to argue anything on ZH Tanzania type grounds by reference to your UK born child. And if we turn to the next slide, you'll see that they propose to exclude people from two sorts of nationality applications. Firstly, by entitlement, and the ones we're looking at, so that's really applications for registration. And so we're used to looking at those bullets, those 3 bullets at the bottom of the slide. Section 1, subsection 3, where a parent secures indefinite leave in the UK, there's an entitlement to register as a British citizen. If you're born and remain in the UK for the first 10 years of your life, at any point in your life, you can apply even while an adult for registration by entitlement under section 1, subsection 4. That's going to go. And where you're born overseas to a British citizen parent who him or herself is a British citizen by descent, and you come to the UK for 3 years, you'll be shut out from registering by entitlement under section 3, subsection 5 of the British Nationality Act. And so what you will find is that these entitlements, these are essentially kind of, although you're not automatically a British citizen, Parliament has hitherto prescribed that you'll have a privileged form of access to British citizenship. You'll be shut out from all of these, and you'll be shut out because you're born to someone who's defined as an illegal migrant effectively under the clause 2 criteria. And then if we turn to the final slide, please, you'll see that not only applications for citizenship by entitlement, but also those at discretion are also excluded for you and your UK-born children. And so registration of any minor at discretion under section 3, subsection 1 of the British Nationality Act, or even naturalisation as an adult, which is of course at discretion, is also excluded. So no stone left unturned, no nationality provision left behind in terms of shutting you out from the system. What remains, not trying to help them out and adding further exclusions, is that the anti-statelessness provisions found in Schedule 2 of the British Nationality Act are left untouched, as are the anti-discrimination provisions found in Section 4C, section and so on and so forth, and sections 4I and onwards, and dealing with those born to parents not married to each other at the time of birth. Very pernicious. It's designed to be lifelong and hereditary exclusion. Those are the key takeaways, if you like. And access to citizenship and children's rights are, of course, issues which may attract some political traction, if not in the Commons and the House of Lords. And so for all of us, there might be some scope here for doing something. I'm going to stop there, mindful of the time. We need to have time for questions. Thank you very much.
Thank you very much to all of our speakers for what is, as we can see, a piece of legislation that can probably only be described as totalitarian, draconian, discriminatory, and, as Adrian said, pernicious. We do have some questions, perhaps just the last question that we've got first, Adrian, because it's a technical question. And the question is whether or not the bill applies to people who have entered the UK illegally before the 7th of March, but claimed asylum afterwards. So what's the focus of the 7th of March date?
The focus is arrival.
So the answer to that is no. If you arrived illegally before the 7th of March, you won't be covered by the legislation. And then there is a question, Irena, that is another sort of technical question about whether or not the identification of the risk of serious and irreversible harm, if you're able to cross that threshold and challenge removal, if you can do what seems to be the impossible, challenge removal for one country, is there anything that would prevent the government using this legislation in respect of another country? So you could face the same process in respect of another country?
Well, I think you could face the prospect of removal to another country, because your claim for this irreversible harm is pinned to the country of removal. So it would be completely consistent with the tenor and the intention of the bill for the Secretary of State to look where else you can be deported. And we know that people have travelled through a number of countries. So no, it will be an endless barrier after a barrier, and I don't think it would. There's nothing in the bill that says there's only one plane. So unfortunately, no hope.
Yeah, and I think you can posit examples of where that might be, that it's a removal to a third country, safe country within the European Union, or even Rwanda, and then to your home country. So those could be the difficulties that you face. And then there's a more broader question which relates to whether or not which parts of the Act are infringements of non-derogable rights under Article 2, 3 and 4, and whether or not they're likely to be subject to challenge under Section 4 of the Human Rights Act. So if we kind of break those down, basically Articles 2 and 3 would relate to the inadmissibility provisions, potentially, and the loss of suspensive rights of appeal. I don't know, maybe Nadia, you could answer that question. Do you think that there's arguments for incompatibility in respect of the substantive protections for human rights in Articles 2 and 3?
Yeah, I mean, certainly, and I know that Article 4 is going to get dealt with probably in a lot more detail. I think it's at the next webinar, isn't it, when trafficking is going to be dealt with in a good bit more detail. I think the point about Section 4 of the HRA is interesting. While it's not expressly disapplied, as we've heard, even getting access to the courts to mount any form of challenge is going to be a massive hurdle to overcome. But certainly there's nothing precluding once you get there from mounting that kind of challenge. The final questions are around timescales. I mean, how long is a piece of string in terms of things getting before the Strasbourg court? It's many, many years as things stand, as far as I understand it. Timescales at the moment, it's sometimes 4 or 5 years to get there. I think what will also be very interesting is to see what regulations or what actual provision is put in. So in terms of one of the powers to make regulations relates to interim measures under Rule 39 of the rules of the Strasbourg court, and all that there is at the moment is a placeholder provision, and to see what goes in its place will be interesting to see in terms of more sort of short-term recourse to Strasbourg, as was successfully done with the Rwanda flights. But yeah.
So that might be a question that you could focus on as well, Irena, on the non-suspensive provisions and how they're likely to fare. For example, is the case law relating to no notice removals going to be relevant?
Sorry, I'm on mute. I think sadly we are well set up to see what kind of challenges and arguments we can make because of the recent incremental attacks on the rights of migrants to challenge removal. So all of that case law is going to be highly relevant. And I think there was also a question about timelines. I mean, this will need really quick decisions by first of all the Secretary of State, but then also quick decisions by the courts and of course by legal advisors who are challenging this. I mean, I think just in terms of the non-derogable rights, I know that that's going to be dealt with in further sessions, but it seems to me that particularly in relation to Article 4, it's absolutely clear that this bill is in direct conflict with Article 4. It is extraordinary to me that all of the protections are disapplied.
Adrian, I don't know if we have another question on compatibility. Any other elements of it that you think are liable to be subject to an application for under Section 4, the HRA?
I mean, the treatment of people in country in terms of detention obviously raises questions about compatibility with Article 5, particularly in the light of the amendments and pegging back of common law, Hardeal Singh style judicial control of the lawfulness of detention. And so if there's no ability to interpret the provisions which permit lengthy detention in breach of Article 5 / Hardeal Singh criteria, you might get a declaration of incompatibility under Section 4. But I think one of the things we need to be careful about is that government amendments, these bills are often drafted in haste, and our experience over the last couple of acts of Parliament is that the government themselves put amendments down to tighten things up as these points are raised when the bills are in passage. And it may be that we see a Section 4 or a Section 4 HRA exclusion coming our way. I mean, it's also, of course, Section 4 powers for remedial orders obviously discretionary and in ministers' hands, and they may feel that they don't need to do anything if a Section 4 declaration is made. So it may be that they think that's their insurance.
Yeah, and it does seem that by attacking and disapplying the Section 3 duty, the government is more than happy to have the issue of the incompatibility that it suits their political agenda to that be the only remedy that the court might have. Thank you. And just so it's clear, you are going to have another seminar tomorrow on detention, but it is important to note that the provisions are also a fundamental attack on common law, long-standing common law protections. And the baseline of Hardeal Singh, because it not only does it leave the matter for the Secretary of State rather than the court to determine what's reasonable, it excludes from consideration obstacles to removal, which, as we well know, the obstacles to removal are the primary reasons why detention becomes incompatible with the Hardeal Singh principles. So that will be a real problem because obviously Article 5.1 reflects is coterminous with the Hardeal Singh provisions, and you also have this the ouster, which would limit challenges to habeas corpus, which, as we know, is concerned with the existence of the power to detain rather than how it's exercised. So I think it is important for us to always remember in this bigger debate that what they're doing here is a massive attack also on long-standing common law protections. There is a question which it hasn't been covered, but is an important one. It's about Article 31 of the Geneva Convention and whether that is infringed by the inadmissibility provisions. And we know that from the Rwanda litigation that removal is not a penalty for the purposes of Article 31, at least at the High Court level. But if we're now focusing on inadmissibility as being the consequence of illegal entry or travel, I don't know who would like to answer that question, if anybody's already thought about that. Adrian, can you want to address that?
So I think this question of whether it's a penalty, I mean, its draconian nature lies partly in the fact that the question of coming directly, which is in clause 2, which is obviously the language used by reference to the Refugee Convention and its interpretation, is now going to be given a statutory meaning. And so it's as much about whether it's a penalty as whether you're shut out from access to the convention at all, the Refugee Convention at all. Coming directly hasn't been understood in the narrow sense, which is being defined in clause 2 of the bill. And there's a lot of case law that says it's more liberal than that. If you're coming to join family in the UK and you're on your way, and yes, you pass through France, you can be coming directly, and you come to the UK and a penalty would not be imposed. Now it says if you're passing through or stopped in a country in clause 2, then that obviously gives a statutory definition to that, and therefore could be inconsistent with the Refugee Convention to the extent that you can find a court where that issue is justiciable, because of course we're dealing with primary legislation, then you might have a point. And certainly UNHCR as the supervising surveillance authority of the convention could have make political representations on that point. But yeah, I mean, it does bring that into play in a very direct way because of the use of that language. It's directly on point, and it's deliberately trying to shut out the idea that coming directly is broader than the clause 2 definitions.
I think if there is a Canadian Supreme Court decision that did treat inadmissibility to the procedures as a penalty for the purposes of Article 31. So I think that argument is definitely open. There's a follow-up question on that, which says, which asks whether or not could protection only be obtained if another country challenges the UK's general breach of Article 31 with this bill.
There's a much unused interstate procedure for a question to the ICJ where states disagree with each other on the Refugee Convention. I doubt there'll be a flurry of litigation in The Hague on it, but it's finding
I think probably France is not going to ask that question, not when they've got 500 million for policing their own border from us. So that probably looks like no, but there we go. So there is a question about Section 55 of the Borders Act 2009 and the duty under that, which isn't specifically addressed in the bill. Irena, is that something you've considered? So what is the effect of the fact that Section 55 appears to be not specifically disapplied in terms of the duties to children?
Well, I mean, you're right, it hasn't been specifically disapplied, but it is directly contrary to both the terms and the intention of Section 55. It is one of the ways in which this bill is illegal, to bring it back to the way that you opened the seminar. I mean, the treatment of children, not just accompanied asylum-seeking children, but all migrant children who are caught by this section, even unborn ones, has no regard to the best interests of children. And of course, that is the duty that's categorically imposed on both the Secretary of State and the courts who are considering actions which affect them, and it's in direct contradiction. I mean, there's a lot I could say, but there is a more detailed seminar, I think the third one of these, that will look much more closely at the obligations to children and the way that it's breached. So I recommend going to that for further detail.
Yeah, and what you've got here is primary legislation as opposed to statutory guidance, which is essentially what Section 55 did. So we're also, one broader question is whether or not the legislative creep in relation to this bill, once enacted, sets precedent in other areas. So Nadia, given the impact on the human rights protections, maybe this is a practice run for seeing if Suella's strategy, which was to legislate the ECHR out of existence, is going to work. And I don't know whether you think there are implications for this approach being applied more generally to other contentious areas.
Yeah, I mean, I think definitely, I think that's where it's important to view this bill not in a silo, but in the broader context, and kind of over the last however many years of well, it's always kind of coming and going, isn't it? The attempt to repeal, replace, reform the Human Rights Act. I think most recently what we've seen with Rab's Bill of Rights bill is that it's been shelved on a number of occasions. Almost everyone has described that framework as completely unworkable and not achieving the government's objectives. And then what we see in this bill, which I think then again, yes, we think about other controversial areas, if they're able to kind of repeal, replace, reform through the back door, and if that works for them, then yes, I think it definitely is what we should be looking out for.
And thank you. There was one very general question about the justifications for the bill. I think we might struggle to find a justification for it, but Irena, you dealt with what was in section in clause 1, but what is the justification for it?
Well, I mean, all I can say is that the stated justification, which I think we have highlighted why it is highly unlikely, if not almost uncertain, not to be met, so it's going to fail. And the stated justification is to deter people from coming here through illegal and unsafe routes. And instead it's pointing them to fantasy routes of safe and legal migration. So the status says, don't come here because you will live as a second-class citizen. I think that's the justification, but I feel somewhat uncomfortable with with putting the government's case for them.
Yeah, well, I think that it's been widely recognised because of the combination of factors that we've explained today about how extraordinarily draconian it is, how much it would depend on something that's impossible for them to achieve, which is safe and legal routes and wide-ranging arrangements with other countries, that it is, I think that the opposition have described it as a gimmick. It does seem to follow on very clearly from other forms of xenophobic kinds of propaganda and blatant electioneering. That would be how I see what's going on here. But of course, that doesn't mean to say that once it's on the statute book, it won't have very real and enormous effects on those it's aimed at, and obviously more widely on our legal system and our standing as a country that can credibly say that we have any commitment to providing international protection to refugees and others in need of international protection. And I think that maybe does lead just onto the question of what can we do before we get to the point of legal challenges of the kind that we've discussed today. And I think we can say, seeing what happened with the intervention from Gary Lineker, that the propaganda war is not lost, and that there is scope for presenting the alternative and the other side of what is going on here. It's cruelty, it's inhumanity, and it's illegality. And we've got an important role to play as people who have direct experience of individuals who and the massive harm that these kinds of measures present, of entering into that debate and that dialogue. I've seen something very effective from the Refugee Council. They've put out from different kind of celebrities, but about why this is wrong. And I hope that people will engage with organisations. ILPA is leading on some on parliamentary response. Other organisations, Justice, Amnesty International, the Refugee Council, the detention organisations, and those consortiums dealing with children are all actively participating in ways in which to present the alternative message and to see how this can be engaged in Parliament. I think it's widely recognised that there's likely to be very little useful detailed debate in Parliament in the Commons. It's going to be heard on the debate is the 27th and 28th of March. But if you do have good links to your member of Parliament who might stand up in Parliament and say something, providing them with information, examples of what might be the impact, useful questions to expose what's wrong about this bill. And I think all of those things are important to do. There's more likely to be detailed analysis in the House of Lords because it's following the ordinary procedure with a committee and the opportunity for questions to be put. And so again, if you've got an interest in responding and assisting with any parliamentary work before it becomes law, then I think any of those organisations would welcome input and support, whether it's in drafting amendments or identifying policy issues or implications, or providing case examples, which are always probably the most effective way of illustrating just why these measures are so outrageous and harmful. The Law Society and the Bar Council are also organisations that we would want to bring their institutional positions and competence to this debate. It had a success in the detention time limits strategy, at least as far as the House of Lords was concerned. That was passed, although of course it didn't become law, but it does show that the House of Lords is the area in which you can make your points most effectively and at least create a dialogue and a discourse that is something different from what the government is announcing at a time when obviously Labour's policies may be somewhat in flux. It seems to be an important point to be credibly explaining why all of this is beyond the pale And so if you're able to participate in those ways, I don't know if anyone else has any other comments on how you might usefully engage before it becomes a law. I hope I've covered everything then. And that being so, I hope tomorrow, if you're able to, you'll attend the two seminars that are coming up that will look more carefully, more closely at other parts of it. But I think that's given you as good an oversight of the challenges ahead, whether that be constitutional crisis, pariah status for the United Kingdom as a country that is supposed to respect fundamental rights and international law, and of course the prospect of the most shocking denial of rights and respect for human beings that we've seen in legislation in our lifetimes. And yeah, it's really a frightening and salutary piece of legislation that I think Lineker was right, has echoes of the 1930s, both in its language and in its effect in creating what's been described as creation of outlaws, of excluded people, their families and their children. And on that note, we'll end the seminar. Thank you for participating.